Dear colleagues, I'm Professor Eduard Ivanov, a frequent visiting lecturer at the International Anti-Corruption Academy in Luxembourg, Austria. I'm glad to introduce you the first IACAS online course on the use of anti-corruption compliance standards and guidelines for designing and implementing an anti-corruption compliance program. In the previous lectures, we discussed risk assessment, applicable laws, and corporate principles and values. And I shared with you the main recommendations of anti-corruption compliance standards and guidelines on these topics. When the risk assessment is conducted and applicable laws and corporate principles and values are defined, you have a base for drafting your anti-corruption compliance program and the code of conduct. The code of conduct and the anti-corruption compliance program should be adopted as internal legal documents and establish legal obligations for your managers and employees. The anti-corruption compliance program can be a separate document or a part of your global compliance program that covers various types of compliance, for example, antitrust or environmental compliance. You should also implement relevant anti-corruption provisions in other corporate policies and labor contracts. When you describe your anti-corruption policies and procedures, please don't forget to check if you have sufficient resources that are necessary to implement these policies and procedures in your company. Designing an anti-corruption compliance program is not an easy exercise. In my last lecture today, I will share with you the most useful recommendations of anti-corruption compliance standards and guidelines on the frame of the anti-corruption compliance program and on key provisions that should be implemented in your anti-corruption compliance policies. Let me start with the code of conduct. The code of conduct is a political document that declares an official position of the company regarding corruption. At the same time, the code of conduct is a legal document. I would define it as a company's anti-corruption constitution. And as a legal document, the code of conduct should contain clear legal definitions and descriptions. It is not enough just to say that the company doesn't accept any form of corruption. Many of your employees are not lawyers, and you should define very clear in your code of conduct what kind of behavior is absolutely unacceptable in your company. As discussed in previous lectures, you should also define very clearly the position of your company regarding commercial bribery and facilitation payments. The code of conduct also defines your main principles and values. You may decide to use the concept compliance beyond the law and make a statement that particular behavior, which is not necessarily illegal in some countries, is absolutely unacceptable in your company. The code of conduct also defines a role of top and middle management in maintaining an anti-corruption compliance program. Many international anti-corruption compliance standards and guidelines underline the important role of the code of conduct, but surprisingly, only few of them contain concrete recommendations on the content of the code of conduct. According to our study, the most meaningful recommendations can be found in the guidelines published by the French Anti-Corruption Agency. The principles and values declared in the code of conduct should be implemented in an anti-corruption compliance program. The anti-corruption compliance program is a second main document that consists of anti-corruption policies and regulates on daily basis all the anti-corruption measures in company. The anti-corruption compliance program should describe an anti-corruption compliance management system in your company. The main principle of this system is a tone from the top and tone from the middle. The anti-corruption compliance program should describe the roles of governing body and top management. In small and sometimes middle-sized enterprises, also shareholders can play an important role in promoting anti-corruption culture in company and in supporting anti-corruption measures. The anti-corruption compliance program should also define which unit or department is responsible for anti-corruption compliance and define the rights and obligations of an anti-corruption compliance officer. All the anti-corruption compliance standards and guidelines mention that the anti-corruption compliance officer should have a direct access to the CEO of the company and, if necessary, to the board or to the audit committee of the board to report cases of corruption or provide any other important information related to anti-corruption measures in company. If you have branches or representative offices, you should also describe in your anti-corruption compliance program how you will communicate with branches or offices. If you will build up a centralized or decentralized management system. Finally, you should define how you promote anti-corruption in your relationships with third parties. To mitigate risks of corruption by doing business with third parties, the International Anti-Corruption Compliance Standards and Guidelines recommend companies to apply anti-corruption clause to the contracts with third parties. The anti-corruption clause is a part of contract that establishes legal obligations of your business partner to take necessary anti-corruption measures. Violation of the anti-corruption clause is a legal ground to suspend or terminate the contract. In 2012, the International Chamber of Commerce published special guidelines on the anti-corruption clause that can help you to define the content and to apply the anti-corruption clause to the contracts with your business partners. One of the most important policies aimed at the prevention of corruption is a policy on third parties' due diligence. The due diligence is a huge topic described in several special anti-corruption compliance guidelines. In my short lecture, I can only provide you with a brief overview of due diligence. The Anti-Corruption Compliance Standards and Guidelines recommend to carry out standard and, in some cases, enhanced due diligence. Sometimes companies carry out simplified due diligence when there is no one risk indicator was identified. The due diligence process starts with the identification of a third party, a representative of a third party, and beneficial owner. Companies also should identify third parties who are public officials or public officials' family members or close associates to mitigate risks of corruption. It's also important to collect and analyze data available from open legitimate sources. In the frame of due diligence, you can identify indicators or red flags which require an enhanced due diligence. When you see that there is not enough information to decide if you should start doing business with this third party or not. As a result of due diligence procedure, you should prepare a report for the following decision regarding conducting an enhanced due diligence entering or not entering into a business relationship with third party, assessment of corruption risk, and defining necessary risk mitigation measures. A part of due diligence is the identification of beneficial owners. Domestic legislations contain definitions of beneficial owners of legal entities, trusts, and in some countries, even definitions of beneficial owners of physical persons. There are two main approaches in countries to the mechanisms of identification of beneficial owners. The European Union decided to establish registers of beneficial owners in all the EU member states. In 2021, all these registers should be interconnected. The Russian Federation established the legal obligation of legal entities to know who are the beneficial owners and to provide this information by requests of authorized governmental authorities and of financial institutions and designated non-financial businesses and professions in a frame of anti-money laundering due diligence. You can establish obligation of your business partners to provide information about beneficial owners in the anti-corruption clause to your contracts. The third party's due diligence creates a base for the following risk assessment and mitigation. The policy on third parties' risk management should contain a risk scale and a list of corruption risk indicators, or so-called red flags. It should also define a correlation between the results of risk assessment and approval of entering into a business relationship with a third party. There are several anti-corruption compliance guidelines on third parties' risk management. These guidelines contain examples of risk scale and recommend to consider particular risk indicators. The anti-corruption compliance standards and guidelines also recommend to conduct a periodical revision of risk category and take into account new information that can be collected by doing business with a third party. Based on the results of risk assessments, you can develop and implement necessary mitigation measures. Sometimes, when you buy shares of a company, you can also buy corruption relationships that have deep roots in the past. In this regard, when you plan serious investments or establishing joint ventures with your business partners, a serious anti-corruption due diligence is required. You can have special provisions on principal investments, controlled fund acquisitions, and joint ventures in your policies on third parties due diligence and risk management. You can also develop a special policy in the frame of your anti-corruption compliance program that will regulate these deals and necessary due diligence and risk mitigation measures. There are not so many recommendations on this topic in anti-corruption compliance standards and guidelines, but you can find some useful ideas in a guidance published by the Wolfsberg Group in 2017 and in the Resource Guide to the US Foreign Corrupt Practices Act, published in 2012 by the Criminal Division of the US Department of Justice and the Enforcement Division of the US Securities and Exchange Commission. The next policy that should be included in your anti-corruption compliance program is a policy on conflicts of interest. The conflict of interest as such is not a crime, but it can be a cause of corruption. Therefore, it's very important to identify and resolve conflicts of interest. The anti-corruption compliance standards and guidelines describe typical sources of conflict of interest: gifts, benefits, or hospitality, outside appointments, sometimes even parallel internal positions, financial investments, employment of relatives, and engagement of public officials. There are several methods of identification of conflicts of interest. The first one is the disclosure of possible conflicts of interest by all employees, relevant business partners, or by selected representatives. You can foresee in your anti-corruption compliance program a regular disclosure of possible conflicts of interests by all employees, for example on an annual basis. Based on the analysis of best practices, I would also suggest you to establish obligation for all new employees to disclose possible conflicts of interests before the labor contracts will be signed. Second method, recommended in some standards and guidelines, is the disclosure of assets by senior managers or board members. You can also identify possible conflicts of interests in the frame of due diligence procedures. You can find useful information on conflict of interests in the ICC guidelines on conflicts of interest in enterprises published in 2018. The policy on gifts and hospitality defines thresholds for giving and receiving gifts and corporate standards of hospitality, considering provisions of applicable laws and regulations. The main idea of this policy is that corporate gifts and hospitality should be not connected or even perceived as connected to particular decisions of your business partners or public officials. The policy establishes necessary reporting and control mechanisms. For example, if your employee, under particular circumstances, had to accept a gift, and she or he has reasonable doubts regarding the price of this gift, the gift should be immediately reported to the anti-corruption compliance officer or unit, and then the employee should follow the applicable provisions of your anti-corruption compliance policy. There are special traditions on gifts and hospitality in some countries, and I would suggest you to consider cultural specifics of countries where your company does business. In this case, you can avoid possible misunderstanding with your business partners or public officials. If you don't exclude that your company can provide charitable contributions, you need a special policy in your anti-corruption compliance program. The anti-corruption compliance standards and guidelines recommend to describe in details the selection process and criteria and implement FOIA's principle. It's important to avoid a situation when providing charitable contributions will be connected to decisions of public officials or business partners, or when a receiver of charitable contributions was recommended by a public official. To guarantee transparency of the use of funds, it's also recommended to include in contracts with receivers of funds an obligation to provide detailed financial reports and necessary financial documents. One of the most important policies is a policy on reporting misconduct and managing hotlines. Your employees and business partners should know how to report misconduct, what to do in case of the bribery extortion. Depending on the size of your company, you can establish various reporting channels. Your employees can report directly to superiors or to anti-corruption compliance officers or units. Some companies establish a separate position of the ombudsman, who is responsible for receiving and analyzing reports. In large and middle-sized enterprises, it's recommended to establish special hotlines that can be managed by the compliance unit or even by external service providers. You need also a special policy on addressing violations. The anti-corruption compliance standards and guidelines underline an important role of training. The anti-corruption compliance training promotes organizational culture and helps to prevent possible misconduct and manage company's reputation. There are several important points to consider when you develop training programs. The compliance training should be tailored. If you want to provide your employees with guidance, case studies, give examples of possible violations, you should take into account the functions of these employees in your company. The employees should be involved in discussions and have an opportunity to discuss possible misconduct in their units or departments. I would also suggest you to check after the training what is the message they received and how the employees can use this knowledge in real life, how they will react on possible violations, how they will act in particular situation in their units or departments. When your anti-corruption compliance program is developed, it should be officially approved by the board or the other governing body of your company as an internal legal document. After that, the anti-corruption compliance program should be communicated to personnel of your company, business associates, governmental authorities, and civil society. You can find useful information in guidelines published by UNODC, International Chamber of Commerce, and the Wolfsberg Group. Dear colleagues, it was the last part of my short course on the use of anti-corruption compliance standards and guidelines for designing and implementing an anti-corruption compliance program. Some anti-corruption policies that we have briefly discussed today can be separate subjects for new lectures or even courses. We would appreciate your feedback. If you have comments or ideas on new lectures or trainings, if you would like to discuss particular anti-corruption policies or procedures, please don't hesitate to contact the International Anti-Corruption Academy via email, online training at ayaca.int. Thank you very much for your attention.